早晨，我哋而家咧係
Good morning, members. This is the appointed time and we have a quorum. Welcome to the meeting of the Bills Committee on Construction Industry Security of Payment Bill. Let me invite the administration in first. Good morning. In relation to the items raised at the meeting of the 29th of October 2024 by members, as well as the written questions put by Mr. Tony Chair, the administration has provided written responses there respectively. CB bracket 1 1453/2024 bracket 02 and 03. The administration has also responded to the written submission provided by the Hong Kong Bar Association, and that is CB bracket 1 1452/2024 bracket 01. I will invite the administration to go through the three papers. Members, if you have questions, please press the request to speak button. Permanent Secretary. Good morning, Chairman, members. I'd like to thank members for their support on this bill. We completed the clause-by-clause scrutiny on the last occasion. Members have given us some invaluable views which are very useful in helping us improve this bill. Today's meeting is for us to discuss the committee stage amendments to be proposed by the administration. We'd also like to address some of the concerns raised by members as well as the Hong Kong Bar Association. There are also a number of amendments relating to drafting improvements. We already issued the paper yesterday. After the last meeting, we also received 2 letters from the Secretariat. They relate to the items raised at the last meeting of the 29th of October, as well as some questions put by Mr. Tony Chair. We also responded to the Hong Kong Bar Association's written submission on the last occasion. And we've provided written responses to all the 3 papers I mentioned on this occasion. Chairman, if I may, I'll invite Mr. Adam Tang, PAS, to respond to all the 3 papers by walking members through these response papers. Let me go through the 3 papers. The first one is bracket 02. Members are concerned about the phrase material denial of natural justice and the corresponding Chinese version 嚴重違反自然公正原則 in clause 48(1)(b) as to whether they are consistent. The reference to a material denial of natural justice refers to significant violations of natural justice that are not minor. According to the dictionary meaning, there is no inconsistency between the 2 language versions. There is no unambiguity, and it can accurately reflect the policy intent. There are other legislation in Hong Kong that uses the term serious to mean material in English. The second point relates to the circumstances under which the Court of First Instance refuses to grant leave and whether the party could lodge an appeal to the Court of Final Appeal. Now, under the circumstances prescribed in clause 48(1), a party to the process may apply to the court to set aside the adjudicator's determination, and that leave must first be sought from the Court of First Instance. We've sought legal advice in relation to the member's question. making reference to the relevant arbitration laws and the rules of the High Court. Any appeal against decisions made by the Court of First Instance require leave from the court. However, under common law, High Courts retain jurisdiction over the lower court's decisions and may exercise this jurisdiction in exceptional circumstances to review the lower court's decision to grant leave. Could you please give us a little bit more details, because you talk about the principles. The question is directly whether in the event of CFI's refusal to grant leave, the party could still lodge an appeal to the CFA. According to the arbitration ordinance, CFI's leave is required in order to lodge an appeal after the adjudicator has made a determination. But in some circumstances, the appeal can be directly lodged to the CFA. So since CFA has jurisdiction over CFI, it is possible that an appeal can be lodged directly to the CFA. So it's not ruled out, correct. The third point is for the administration to consider, by drawing reference to the practice of the ordinance in Singapore, consider providing that the costs of adjudication proceedings due constituted a debt so as to better protect adjudicators. Now, the bill specifies that the adjudication costs include fees and expenses of the adjudicator. And it's also prescribed that the determination will not be delivered to either party until the fees have been paid. And that at appropriate stages, adjudicators may request the payment of deposit of further deposits by parties through the nominating body. Clause 53(3) provides that both parties are jointly and severally liable for adjudication costs. For similar pieces of legislation with security of payment in other countries such as UK, New Zealand, and Australia, similar provisions are put in place to ensure that adjudicators receive payment. In the arbitration ordinance or in other pieces of legislation in other jurisdictions, there is no specification of unpaid adjudication fees being debts. We've also consulted the industry and professional bodies. They believe that the provisions in the bill are sufficient in ensuring that the adjudicators receive the fees and payments so due. Right, so now there is clarity that there is no need to have extra safeguards put in place. The member suggested that a cross-reference be included in Clause 43(2) to indicate that an adjudicator's determination regarding an extension of time was subject to Clause 56 of the bill. Clause 56 provides that unless there is it stipulates that adjudicators have no jurisdiction over time-related disputes. And as such, the prerequisite in 42(3) should not arise. So the adjudicators have no jurisdiction to determine whether a party should be entitled to an extension of time in time-related disputes. If an adjudicator makes a determination in contravention of Clause 56(1)(b), either party may apply to set aside the determination on the grounds of the adjudicator acting in excess of the jurisdiction. We don't think it's necessary to include this reference. From the drafting perspective, adding this reference to Clause 56 would be undesirable. If the Secretary for Development exercises the power under 56(3) to render 56 ineffective, the reference would remain pointing to an invalid provision unless the government at the same time repeals that provision, and it is not desirable. It is not appropriate, therefore, to add the suggested reference to Clause 56 in Clause 42(3). Yes, please continue. Now, after responding to the issues raised at the meeting on the 29th of October, we now proceed to responding to Mr. Tony Tse's 4 questions. First, can the period specified in clause 43(1)(a) and (b) of the bill regarding the payment deadline be more than 30 days? Does the adjudicator's determination override contractual terms? Clause 43 specifies that the payment deadline for adjudicated amount should be determined. If the adjudicator does not specify a payment period, the party must pay the amount within 30 days after the determination is served on the parties. There is no deadline specified, no upper limit specified for the payment period in the bill. That means it could go beyond 30 days. The payment deadline is not confined by the contractual terms relating to the payment period. However, we are going to provide appropriate guidance to the adjudicator in the adjudication rules on reasonable payment period. The second question relates to the cost of adjudication procedure in clause 53(1) and whether it includes expenses for meetings convened by the adjudicator for a case such as etc. And will the adjudicator be required to pay in advance? Clause 53(1) specifies that the cost of adjudication procedures include the fees of the nominating body, the adjudicator, the independent experts appointed, or the fees for inspecting construction sites or the completed works. Now, Mr. Jie refers to the expenses for convening meetings. According to Clause 53(4)(a), the parties to the adjudication are obligated to share the payment as per the proportion determined by the adjudicator. As explained just now, we will establish guidelines in the adjudication rules and that the parties will be required to pay a deposit. The third question relates to whether the term any private main contract or its subcontracts in clause 56(1) includes subcontracts. We've specified in clause 56 that in the first stage, the adjudication mechanism does not apply to time-related disputes for main private contracts and subcontracts. The Secretary for Development will appoint an effective date for implementing the mechanism for such disputes. As for the private main contracts and subcontracts definition, they can be found in clauses 4, 2, and 5 respectively. Clause 56(1) also specifies that the main private contracts and subcontracts include subcontracts in the downstream, according to the definition in Clause 5, so it includes all downstream subcontracts. The fourth question relates to whether elderly homes and residential care homes for the elderly are regarded as premises excluded from the definition of residential unit in Schedule 1. Schedule 1 lists the places excluded, and if the owner is to the contract is a beneficial owner, and if the owner is a specified entity, such as the Hong Kong Housing Society being the owner of elderly homes, then usually the Housing Society will be the signing party to the contract in relation to maintenance and renovation projects. And since the Housing Society is a specified entity, the contract will be considered a public contract. If the public contract value meets that the value specified in Schedule 4 in Clause 1, the bill applies to public contract and its subcontracts. An RCHE is not a residential unit specified in Clause 2(1) of the bill. So that concludes my explanation to Mr. Jie's questions.
And now I would brief members about our response to the Bar Association's letter dated 21st of October 2024. On the 29th of October at last meeting, we have already briefed members about our response, so I will be brief today. The Bar Association is concerned about the mandatory execution application as well as the application for leave, it might add on the burdens to the judiciary institutions. As mentioned, the only thing we need to ensure is the quality of the adjudication so that both parties can accept the result of the adjudication. In that case, there will be minimum requirements on the intervention of court. And the application for leave of the adjudication is also limited. We will strengthen publicity works in order to minimize such requests. We are also in close connection with the judicial institutions. In case of extra workload, we will review the resources and seek for additional resources in a timely manner. Upon our communication with the judicial institutions, we both understand that the objective of this legislation is to speed up the adjudication mechanism in order to resolve the payment issues in the construction sector. They will also allocate resources in order to handle the case in a timely manner. In response to the concerns, in clause 48 and 49, we will put in some related amendments. There are three major aspects. First, local courts and the court of first instance will be able to take care of mandatory execution and the application for leave within the jurisdiction so that they can apply or make use of the resources in an effective manner. For the application of mandatory execution, there shall be flexibility allowed. Within a period of 14 days or in a reasonable period of time, they have to come up with a ruling. We will also empower the court of the CFA to set out rules in order to streamline the application to court. As we discuss about the CSA, we will give you more details about the above amendments. That's all I would like to brief the members. Thank you. Any members who would like to put in questions in response to the administration's response? Yes, Mr. Lai Tong Kwok. 4 minutes. Thank you, Chair. I would like to ask for further information. In your first response, at the last meeting, members concerns that the party who apply for leave, they wonder if they can apply for an appeal from the CFA. You said that you have taken reference to the related adjudication rulings as well as the procedures rules of the CFA. After this legislation is passed, there might be disputes arise. Is it possible for us to quote related regulations in the adjudication rules? Second, you also mentioned that according to common law, High Court is entitled to review the rulings of the lower courts, and you also mentioned a certain case. However, in this case, you did not quote a number. Therefore, it is impossible for me to refer to such court. Is it possible for you to provide related reference number so I can take reference into it? Thirdly, apart from two reasons that has been given, is there any specific reason, for example, the ordinance of the Court of Final Appeal? Is there any specific rules that give the ruling powers to such court in whether or not to give an adjudication? Thank you. Thank you, Mr. Lai. If both parties is unsatisfied with the adjudication, they wonder if they can further appeal, or if they are unsatisfied with the actions of the court, is it possible for them to apply for appeal? And what we have put into writing is that they need to be approved before they submit an application of appeal. We have already taken reference to the arbitration ordinance. But when we talk about the adjudication, we have to take reference to this existing legislation. We also taken similar references. As respond, in common law, there is such mechanism in place. When a higher court see a special situation, which has to be decided by the court. Some examples is conflict of interest. In such situation, the higher court can rule regarding to the application for appeal. I would like to seek our legal advisor to submit to it. We also have the number of that court case. We will supplement later by our legal advisor. Mr. Zhang? Thank you, Chair. And thank you for your question. Let me submit to you about the case number, because in the letter, such number was not quoted. The case mentioned is China International Company Limited. It's bracket 2016 1HKC 35. It is a reported case. It can be found. This is for your reference. Quoting related case law and common law, it gives us the conclusion that a higher court has the residual judiciary in the lower court's case. Through this case law, the higher court has the power to supervise whether or not the court of first instance will approve such appeal. We also consult a related advisory body, and we have received that they believe we only need to quote such case law in order to find the principles to allow the higher courts to rule or to supervise the decision of the lower court, exercising the residual judiciary power. So after quoting this case number, I believe that members can receive further details in order to understand such principle. There is no further question. And we will now move into the scrutiny of the CSA. Kindly be reminded that the Secretariat has already sent out notifications on the 29th of October 2024 asking if members will put in any amendments for this committee. As of the deadline, the Secretariat did not receive any draft of amendments from members. The administrations will put in the CSA, and the draft is already listed in Legislative Council Member CB bracket 1 1453/2024 bracket 04. And may the administration now brief members with the content of CSA. Members who would like to ask questions may press the Ask to Speak button. Mr. Tang? Thank you, Chair. I trust that you have already have the Chinese and English versions of our CSA. Some is in Chinese only and some English only, so I will go through them in order one by one. Item number 1. Item number 1 concerns some slight revisions for grammaticality. May I refer you to English version Appendix 1? In clause 6, bracket 1, bracket B, bracket Romans number 3, on the 3rd of October, the committee mentioned that in the English versions, there needs to be some revision for grammaticality. And we have added the preposition of, disposing of. This is to amend according to member suggestions. Any comments? Please continue. Item number 2. May I refer you to Appendix 2? On On page 10, clause 9 bracket 1 bracket A, on the 3rd of October, members suggested that when in clause 9 bracket 1 bracket A, when they talk about where the ordinance does not apply, well, our intention is that if the price they pay is not according to the value of the construction's work, for instance, the operation, the design, as well as the operation during the work, for these type of contracts, ordinance does not apply. Members said it is misleading and unclear in the ordinance. People might think that the application of ordinance is not covering the works that is already going on or the provision of products and services. In this regard, we have revised clause 9 bracket 1 bracket A in order to specify more clearly where the ordinance does not apply. Under clause 2, paragraph B, line 3, according to the amendments in clause 9(1)(a), there is also a revision in the definition of development contract. And our apologies, going back to clause 9 bracket 1 bracket A, in paragraph B, there is also a change in wordings. In line 4, we have added the Chinese word 等, because in English, it is in plural form, provisions. Therefore, in Chinese, we have added the word 等 in order to clarify. No questions. Please continue. Mr. Chen Xiuhong, Vice Chair. Thank you, Chair. As I discussed with the industry, we concerns about where the ordinance apply and does not apply. And I find it difficult to explain when we need to talk about the calculations of the provision of products and services that is outside of the contract scope. I think some people still find it difficult to understand. Is it possible for you to cite examples? Under which circumstances shall we calculate not according to the value of the provision of product and services under the construction contract? Thank you, Member. In the construction industry, there is a kind of work called design, build, operate. There are contracts of this kind. In design and build, if the upper-tier contracting party will pay according to the amount of work that is done. In the ordinance, if they fulfill the requirements, then such work will be covered. In terms of operation, it is not paid according to the amount of work done. The subcontractor will receive certain proceeds in order to compensate the cost during the construction work. In clause 9(1)(a), this is not covered.
Right now, it's clear 1A refers to such a situation. I think I also made a point about this at the last meeting. Say, if the time span is one of 10 or 20 years, then the calculation is not done on the unit of work carried out, but on a quarterly basis or yearly basis, and subject to certain terms and conditions. The value will only be calculated after maintenance period ends. So I understand that what the value of work or goods captured are captured here. Now that it's clear, I don't want to further amend this provision, because as discussed last time, I'm afraid that we cannot make an exhaustive list of the scenarios here, and it will not be appropriate to do so. So after passage of the bill, when the mechanism takes effect, I urge the administration to provide guidelines or FAQs to help us understand. Now it seems easy to understand, but with the lapse of time, there may be ambiguity. So I think some sort of guidance or FAQs would be very useful for the sector. Well, I think what we said just now will be recorded in the minutes, and this can reflect the legislative intent. But of course, like Deputy Mr. Chan said, guidelines can be provided to help the industry understand the clause better. And Deputy Chair doesn't have any further comment on the proposed amendment, right? It's an improvement on the existing clause. Right. Well put, Chairman. Our deliberations are put on record, and I think in the future it will be useful reference for courts and adjudicators in resolving disputes. The record shows the legislative intent, and it helps save disputes about the calculation of the value. Right, Mr. Tang, please continue. Let me also respond to that. I agree, Chairman. When we draw up the bill, we provide the broad principles. As for the actual scenarios, I believe the industry should rely on the rules, the guidelines, publicity documents, or FAQs. Mr. Tang, please continue. Item 3. An English version amendment. Please turn to Appendix 3. Clause 25 3A, and then turning over the page, Clause 25 7. 25A is a revision of an English word. It's a grammatical error. It will be changed from date to day. The other amendment relates to 25-7. Again, the word will be replaced. The word date will be replaced by day. Right, no questions from members? Please continue, Mr. Tang. Item 4. We'll go to Appendix 4 now. Clause 38, parties may be represented. At the meeting of the Bills Committee on the 21st of October, members mentioned reference to overseas legislation, and that the Hong Kong International Arbitration Centre has also amended its rules. That is why we are putting in this amendment. In the adjudication process, if a party changes its representation by adding or substituting new representative, if the adjudicator considers that the appointment of the new representative may give rise to a conflict of interest or justifiable doubt as to the adjudicator's independence or impartiality, the adjudicator may exclude the proposed new representative from representing the party in the proceedings. We responded to this suggestion earlier, and we are now making an amendment to Clause 38(2) by this additional provision. Right. We raise this point. Perhaps a party to the proceedings may wish to replace the existing representative with a new one, and there could be a case of conflict of interest impeding the proceedings. Mr. Louis Long. Just a point of clarification. Is it within the adjudicator's exclusive power to decide on the appointment of the representative on the basis of possible conflict of interest, or is there anything that could limit the adjudicator's exercising of this power? The simple answer is yes. The adjudicator has absolute power, but of course in the process there should be communication with the parties. Mr. Tang, please continue. Item 5. Please refer to Appendix 5, Clause 39 relating to resignation of adjudicator. The Bills Committee made the suggestion on the 21st of October. Pursuant to clauses 39.1 and 39.3, the resignation adjudicator shall serve on the same day a written notice of resignation on each party and the nominating body. Clauses 39.2 and 4 are revised accordingly, such that the resignation takes effect on the date on which the written notice is served. So, as to improve the clarity of this provision. Right, this is based on the suggestion we made last time. The notice should be served on the same day. Please continue, Mr. Tang. Item 6. Clause 39.3. This is a drafting amendment in response to the amendment we just went through, and it clarifies that during the process of adjudication, if the adjudicator considers that conflict of interest or circumstances which give rise to justifiable doubts as to its independence or impartiality have arisen, the adjudicator shall resign pursuant to that clause. Any questions? Please continue. Next, item 7. A revision to the English rendition. May I invite members to go to Appendix 7 now? Yes? I have a question. 39.3b. A person other than the adjudicator has justifiable doubts as to the adjudicator's independence or impartiality in considering the payment dispute. Justifiable doubts. So the person must have been engaged in certain process to raise his justifiable doubt. If it's yet to be ascertained, as long as justifiable doubts have arisen, does it mean that the adjudicator will need to resign immediately? Let's say if somebody makes a complaint or raises an issue as to the possible conflict of interest in relation to the adjudicator, then shouldn't there be a process to ascertain and determine whether this allegation is justified, and that before this process is completed, the adjudicator shouldn't be required to resign immediately? Can you explain what steps we should follow? A person, well, I think it refers to the issue being raised as explained, and there is no time frame specified. Whenever this circumstances arises, the adjudicator should resign, and details will be provided in our guidelines. We will tell the adjudicators the circumstances under which the adjudicator should resign in a timely manner. I understand that you are going to put the nitty-gritty in the guidelines or the rules. I get that. I am all right with the concept of not putting in all the specific details in the main provisions. However, if you rely too much on the guidelines, my concern is that on reading this provision, a prospective adjudicator may be deterred. Because when it comes to adjudication, some parties may exploit this loophole. They may make allegations of possible conflicts of interest of adjudicators. While the industry is small and the adjudicators may have some business ties with some parties in previous projects. So there should be a mechanism to ascertain the allegations, and in the process, the adjudication proceedings should be suspended for us to find out whether the adjudicator has any conflict of interest. So the guidelines should explicitly provide the evidence required, the mechanism to be put in place to ascertain the allegation. And only when the allegation is justified that should the adjudicator serve a resignation notice on the parties. Now, my concern is this. According to the Permanent Secretary, there is consensus for the industry, from the industry to implement the bill as quickly as possible. But if somebody exploits the loophole in such a manner as I describe, then how are you going to address my concern since you haven't drafted the guidelines for our reference? P.S. Thank you, Chairman. Thank you, Mr. Chan, for raising this concern. This is a valid point. Now, this clause relates to the perception of the adjudicator. If he perceives himself to be in a position of conflict of interest, or that there are justifiable doubts that may impact on his impartiality, then this adjudicator should resign. It's not spelled out in the law within how many days or within the time frame in which he should resign. We believe this should not be provided in the main provisions. We need to have regard to the actual operation of the mechanism for the industry. It's for the adjudicator to decide the reasonable time frame. Another way to go about it is that the party may lodge a complaint to the nominating body, and that will be dealt with in another way. I agree that this provision doesn't spell out the time frame within which the adjudicator should resign. If we take a look at subclause 3, if the adjudicator considers and then so and so, any of the following circumstances has risen: A, the adjudicator has a conflict of interest; B, a person has justifiable doubts, that is, the adjudicator faces an allegation of impartiality. Then if the adjudicator must resign on B, then it's really questionable because it's only an allegation coming from one side. Well, if it's according to B, has justifiable doubts as to adjudicator's independence, so on and so forth, and then the adjudicator must resign, then whenever a doubt arises, the adjudicator must resign. That's a trap that can be easily exploited. I mean, in the process, somebody may make an allegation of a conflict of interest, and then the adjudicator must immediately resign. I think this is problematic.
Thank you, Chair. I think it's a matter of wordings because we think the person, you might understand that it is a physical person. Legally speaking, actually it means that it might have such implication. When the adjudicator does certain things, people might think that it can be possible. It is a way of legal drafting. Mr. Zhang, could you please explain? Thank you, Chair. And thank you, PS. Let me clarify. We are talking about the adjudicator's discretion. It is upon the thinking and analysis of the adjudicator. If certain party mention that they have doubts towards the impartiality of the adjudicator, then it is up to the adjudicator to determine if he believes that people are putting forth some reasonable doubt towards his impartiality. Therefore, the discretion and the thinking process lies within the adjudicator. If he believes so, then he needs to resign. So you are asking, does it mean if someone reports or questions about his impartiality, according to the provision here, it is up to the adjudicator to determine if it is the case. And that is how we understand the ordinance. So even if there is a certain party reporting or questioning about the impartiality of the adjudicator, it does not mean that they have to resign. So the key word is reasonable. So apart from the adjudicator, if there is a person who has justifiable doubts as to the adjudicator's independence or impartiality in considering the payment dispute, well, certainly if it is not purely having doubts, but a justifiable doubt that is agreed by the adjudicator. Is it correct? Yes, Chair, understand it correctly. Justifiable doubts is part of the considerations of the adjudicator. He has a role to play. So someone may put forth certain doubts, and if the adjudicator believes that it is justifiable, I think it is back to circumstances A. Vice Chair. The use of words here is justifiable doubts. As Chair understood, in both A and B, when you spell it in such a manner, I don't see the word and. Scenario A is very clear. The first one is when there is no one doubting the adjudicator will initiate and resign. But in scenario B, it is someone who is spelling out their doubts plus the adjudicator's decision. The adjudicator has to believe that it is also a justifiable doubt. Well, if you are exercising B, then the word and needs to be added. For clause B, it's like if 3 bracket A agrees. Can you clarify? Mr. Tang? For 39 bracket 3, the first line, there is one condition here. If an adjudicator considers. So if you read the whole clause in this light, well, let me put it in a layman way. If the adjudicator believes that someone might has justifiable doubt as to an adjudicator's independence, then he needs to resign. So it requires the judgment of the adjudicator. So the key phrase is the first few words in clause 3. Chairman, I would like to talk about the logic for both A and B. I mean, it is A or B. the application of this clause is A or B. And the first line in clause 3 is that if an adjudicator considers the following circumstances, then in clause B it says a person has doubts. It is one of the circumstances. So who is there to determine whether it is justifiable? It is the adjudicator. So someone has doubts and the adjudicator believes that it is justifiable, right? Yes, because in clause 3, right at the beginning, it says if an adjudicator considers. So for clause B, it means if an adjudicator considers a person, etc., etc. Now with his explanation, I can understand, but it is quite complicated. Can you put it in a simpler way? In some previous review, in order to prevent doubts, you might spell out the whole sentence here in an explicit way. It's just my suggestions for your consideration. Okay, so if a person has doubts and such doubts is justifiable, is that what you mean? Yes. Or if the adjudicator finds it's justifiable. That's the meaning here. Does it has to be spelled out? Mr. Lai Tung Kwok. Chair, Mr. Chen Shu-hong has made a very good point. In clause 3b, in English, it said a person. Such person shall not be involved in this adjudication. Is it correct? Let's say a certain newspaper has put forth a doubt in the coverage of this story. Does this constitute a person? Is a question. Well, by a person, I think it can be referring to the general public. If the general public has justifiable doubts, then the adjudicator shall resign. Mr. Tang? Thank you, Mr. Lai. I agree. It is referring to any justifiable person. I think it's just any person. It can be a legal entity or a certain person. As long as someone mentions it, it forms a case. In reality, how can an adjudicator learn about it? Before adjudication, it is impossible for the adjudicator to search it all out. It is impossible. I think the writing here has too broad a scope. Justifiable doubts is a fine phrase here because it is almost certain that it is mentioned by a third party. And it will constitute an objective reality if it is mentioned by a reasonable person. And after that, the adjudicator has to determine it subjectively. It is according to him. Upon his notice, then the adjudicator has to make the final decision. And my remaining question is, if a person doubts the decision of this adjudicator, would it cause any harm to the process of the adjudication? Would it be delayed? Is it possible for other persons to take legal action in order to turn around some ruling in the adjudication? How would you compensate for it? P.S. Thank you, Chair. Thank you, Mr. Lai. By a person here, what we mean is under a reasonable circumstances, if a person has put forth such a doubt, then the adjudicator needs to consider if there is any justifiable doubt to his independence or impartiality. This is how we put it here, and that is what we meant. And Mr. Lai asked if it would lead to potential delay in the adjudication. And it all boils down to the decision of the adjudicator. If he believes it is a case, then he should resign. If not, then he should continue. Throughout the process, if there are people raising doubts about it, or in the procedures, it can be disregarded. In clause 48, we talk about setting aside. People can ask for the cancellation of the adjudication, that is setting aside of the adjudication. That is the procedures that can be taken. Mr. Long Han Bill. Chair, I would like to put forth my point of view. I think it is pretty clear here. Because the overrider here is if an adjudicator considers. In English, it says if an adjudicator considers. So this is the prerequisite. The key point is not what anybody does. The determining factor is whether or not the adjudicator finds such doubts justifiable. If he thinks so, then he shall resign. If the adjudicator thinks it is trivial, then he will continue with the process. Therefore, I think this clause is already very clear. I would like to see if the administration agrees. P.S. Thank you, Chair, and thank you, Mr. Long. As we put in place this clause, we have already explained that the main determining factor is the decision of the adjudicator. No one else can tamper with his decision. In terms of the wordings, I think the key phrase is justifiable doubts, not just any doubts. He does not need to resign upon any doubts. It's also clear in English. Justifiable doubts. So it's not just any doubts. He does not need to resign upon just any doubts. The doubts needs to be justified. Or in Chinese, it's 有理可據的懷疑. Is there anyone else? Vice Chair. Yes, Chairman. Mr. Lai Tong Kwok has put forth the two questions that I would like to ask. What I would like to do is to clarify the applicable scenario of this clause. Because we don't want to see any misunderstanding because of the wordings, and we don't want to see any further delay or the manipulation of the loopholes. Well, I'm talking about any person, be it the media. Sometimes in a coverage, they may say, we doubt that there is a conflict of interest on behalf of the adjudicator in this case. Then you're not sure if the media is responsible or not, so they might stop there and to look into the context and to consider. And the spirit of this clause is to trust in the discretion of the adjudicator. The adjudicator needs not to stop or resign based on just any saying of anybody. The adjudicator needs to judge. He can choose to disregard such doubts or accusation. Whether or not such accusation is established, there are other procedures. They can appeal, they can go to the ANB. There are many procedures that can be used. If such doubts or accusation requires a judgment, there will be other provisions that takes care of the effectiveness of this adjudication. I believe that as we read this clause, the wordings here is enough to solve our concerns.
Mr. Dennis Lau, 39, 2, and 4 I'm reading these two clauses. Now, the resignation mechanism in 4 refers to subclause 2, and does subclause 3 apply? I mean, the adjudicator's resignation takes effect on the same day when the notice is served to other parties. Now, can we simplify the structure by making the same the reference to the same provision? It's a drafting issue. It's the drafting practice. I will give the floor to my DOJ colleague, Mr. Zhang. Thank you, Chairman. Thank you, Member, for the question. It's a balancing exercise. Mr. Dennis Leung has made the suggestion to simplify the structure so that the clause will be less cumbersome. However, there is a difference between subclause 1 and subclause 3, and that is the adjudicator may resign and must resign, and the relative and the respective handling of the resignation matters. Now, the way this is drafted at the moment, in clauses 1 and 2, we find the resignation process in clause 2 referring to the scenario in clause 1 and etc. So if there are no other questions, we go to Appendix 7, Item 7. Clause 46, that's 46 2 or 3. The related goods and services, and we're deleting the word there. No comment. Let's continue. Item 8. Starting from 8 to 19 or 18. They relate to the submission of the Hong Kong Bar Association in relation to setting aside application and enforcement application. Now, as discussed with the judiciary, we have proposed certain amendments. As I explained just now, in relation to the jurisdictions of the CFI and District Court, we're proposing amendments. There are also rules and time frames in relation to the court's handling of these applications, so as to ensure the smooth operation and efficiency of the mechanism. Item 8. Item 8 relates to 6 clauses. In Appendix 8, there are amendments to 6 provisions: 22, 44A, 48.4, 49.1, 49.6, and 55.3. We propose to confer jurisdiction upon CFI and District Court to process set-aside application and enforcement application within their jurisdiction, so as to enable effective use of the court's resources. In the interpretation clause, we provide that court means the court of first instance or the district court. In Part 3, Division 6, in relation to the applications mentioned, these are the 2 levels of court that can process them. And then let's turn to Appendix 9. For Item 9, 48.1AA, that's a new proposed section. We want to provide clarity that a party to adjudication proceeding may apply to the court to set aside the determination. If there are no other questions, I will now move on to item 10. That's in Appendix 10. 48.1 about application for setting aside determinations. At the meeting of the Bills Committee on the 29th of October, we explained that reference has been made to the legislation of security of payments in other jurisdictions. We understand that the court has a jurisdiction to determine whether to set aside, to decide whether to set aside the determination in whole or in part. So we are making revisions to paragraphs A to D of clause 48.1 in the Chinese version to reflect this objective. Any views? If not, please continue, Mr. Tang. Item 11, that's Appendix 11, Clause 48, Subclause 4. We are going to provide clarity through this amendment. The party must pay as security the unpaid portion of the adjudicated amount. In Clause 49, we're going to add another subclause, and the relevant rules will be set out. Any views? Please continue. Item 12. Appendix 12. Clause 48, Subclause 5. We've made reference to the arbitration ordinance. In relation to an appeal against a setting aside application, leave from the court must first be sought. No comments. Item 13. We're on clause 49, enforcement of determination as judgment. Our 13th amendment is as follows. We propose to amend 49.2 to make it clear that this is an application for leave from the court to enforce a determination. Still on Appendix 13, we're going to amend clause 49 bracket 6 as well, and likewise, if an enforcement application is granted under subsection 5. So instead of leave, here it says an enforcement application. Item 14. Also on clause 49, subclause 4. Well, the current drafting is such that the court is required to consider certain matters before passing judgment. Now, we propose to specify that the affidavit should state certain matters, such as the unpaid adjudicated amount due, the fees of adjudication, as well as interest. Is not for the court to calculate these amounts on its own, according to the proposed amendments. Mr. Louis Long. Sorry, Chair. It's just come to my attention. In Chinese, enforcement or 強制執行 in Chinese. In English, it's simply enforcement. I don't know whether this is the proper translation of the Chinese term. Because by common sense, 強制執行 in Chinese carries a sense of compulsory enforcement of the determination. But it's also logical following the announcement of the determination that it should be enforced. So is it necessary to include this element of a compulsory or mandatory enforcement? I don't know whether it's the translation of this legal term. Right, a drafting issue, I will give the floor to the Law Drafting Division. Ms. Lai? Thank you, Chairman. Thank you, Member, for the question. For the enforcement of a judgment or determination in English in the laws of Hong Kong, the corresponding term in Chinese is 強制執行. That means it's a binding process. It's an order from the court for the determination or the judgment to be enforced. Right? That addresses my concern. I'm just saying that in Chinese it refers to a compulsory enforcement. I don't have any strong views on the translation, but I just feel that the Chinese term 強制 has an additional sense of it being compulsory. Or does it mean that one of the parties is reluctant to have the determination enforced? Let me supplement. If Clause 49 is to be invoked, then it's referring to a case in which a party has refused to pay the adjudicated amount. And that is why the other party is applying for leave from the court to enforce the determination. So, in a sense, we believe the term 強制執行 in Chinese can truly reflect the meaning. Well, it's after all a gentleman's game. The adjudicator will be making a determination, and it's not up to the parties to decide whether to pay it or not. I'm not trying to spark a dispute here. Even if there is a dispute, if the adjudicator has already made a determination which is not observed, then it will have to be enforced. Item 15, still on enforcement, Clause 49, Subclause 5. As I mentioned in our response to the Hong Kong Bar Association's submission, we have discussed with the judiciary, and we believe that this adjudication mechanism is a perfect solution to resolving payment disputes. So this amendment relates to the fact that the court should decide on an enforcement application within 14 days or a period that the court considers appropriate. This will allow flexibility for the court to process an application depending on the complexity of the case.
Any questions? If not, Mr. Tang, please proceed. Thank you, Chair. Appendix 16, may I refer you to the corresponding appendix. We were talking about Clause 49, bracket 5A. We want to clarify the wordings in this amendment, proving that this court must not grant leave to enforce so as to assist the court to process an enforcement application. Giving reference to clause 2, 3, 4, 5, the court may not grant the leave to enforce. Any questions? If not, then we may proceed to item 17. Appendix 17, clause 49, bracket 7. In bracket 7, similar to the application for setting aside, we take reference to the related items in the arbitration ordinance. In view of the application for appeal, it requires approval for court before submitting the application. Any questions? Mr. Tang, please proceed. Item 18. May I refer you to Appendix 18. As mentioned, in clause 49A, we will add one additional clause, allowing the chief judge to make rules according to Division 6. The chief judge may make rules to provide for the practice and procedures relating to a set-aside application and an enforcement application under Division 6, and to provide for any provisions that the chief judge considers necessary for expedient. Yes, Chair. Any questions? Mr. Tang, there's no question. Please proceed. Item 19. May I refer you to Appendix 19? It concerns clause 51, clause bracket 2, bracket E. In the last meeting, we proposed that a person may disclose to another person information related to an adjudication if the disclosure is made in any other adjudication proceedings or any court or dispute resolution proceedings that arise from the construction contract in respect of which the payment dispute under the adjudication arises and between the same contracting parties. Any questions? If not, Mr. Tang, please proceed. Item 20. As mentioned in the last meeting, we want to revise clause 59, bracket 1 in Appendix 20. If only part of payment dispute relates to extension of time, the adjudicator can still handle the non-EOT related part of the payment dispute. At this stage, it does not apply to the EOT dispute related to the private main contractor and its subcontractor. We have already talked about it in the last meeting. No comments. Mr. Tang, please proceed. Thank you. Item 21, may I refer you to Appendix 21. Clause 58, bracket 4. At the last meeting, we propose to revise the wordings here. If the claiming party does not specify the intended starting date in its notice of intention, then the 5th working day after the date on which the notice of intention is served on the paying party is taken to be the intended starting day. In other words, we have crossed out the date after. Any comments? Please proceed. There is no comment. Item 22. Actually, it is quite similar to the previous one. Clause 58, bracket 4. We are crossing out the wordings, the date after. Simply put, the date is the 5th working day after the date that the notice is served. I think there is no further comments. Please proceed. Item 23. Clause 61, bracket 2, bracket D. On the Bills Committee meeting on the 21st of June, members mentioned about the 3 documents relating to the nominating party. And both the contents of the adjudication, rules, practice notes, or code of conduct has to be submitted to the secretary. And they need to follow up the 3 sets of documents. In order to make it explicit, in clause 61, we have added an additional clause to give a direction related to a nominating party in relation to clause 61, bracket 2, bracket D. It is very clear. We are clear about the functions of secretary. Any comments? If not, then Mr. Tang, please proceed. Item 24. Body specified in Schedule 3. In the meeting of the 3rd of October, members of this Bills Committee has mentioned that in Schedule 3, major telecommunication service providers need to be added because there are some constructions work related to their companies as well. Accordingly, we have added the major telecommunications service providers' names to Schedule 3. Are you in communications with them? Yes, we did. We did communicate with the related government department as well as the major telecommunications service providers. We all agree to add in this list. Mr. Louis Lung? Yes, Chairman. In 17A and 24B, Hong Kong Telecommunications HKT Limited, 24B, Smartone Communications Limited. These 2 companies has no corresponding Chinese names, therefore you have put English here. Yes, we have checked with Oxford. We have checked the official names of all these companies. Thank you. We have looked into the CSA submitted by the administration in details. And legal advisor? Is there any issues arising from the CSA or the bills? We did not receive the documents from the administration until later yesterday. We need more time to look into the issues related to the legislation and its drafting. If necessary, we will follow up. Thank you. It is the 11th meeting of this Bills Committee, and we have finished the scrutinization of CSA. Vice Chairman has pressed this request to speak button. Yes, Chair. Under the leadership of the Chair, with the highly effective response of the administration, we believe that we are working very well together, and we have already clarified the intention of the legal perspectives as well as the details in execution. Thank you, Chairman, for your leadership. We have completed a critical step. As mentioned in the previous discussion, we did request for some FAQ pack. Many in the industry have requested for a speedy implementation, and there are also questions or doubts about the execution or about the time frame. I find it quite difficult to explain. If PS remember, at the beginning, we did receive a PPT about the payment, the disputes in payment. If there is a mechanism triggered after certain days, certain procedures will needs to be put in place. And after putting in an adjudications, there will be different time frames that follows. May I suggest the administration or the PS to prepare a time frame for the industry so that they will understand after certain days the A and B will respond, and after a certain period of time the adjudicator shall respond, and if they are unsatisfied with the adjudication results they can file appeal. Because all these time frames needs to be understood by the industry as well as the general public, I don't think it is difficult to be done because the administration knows all that. It is only to help the general public and the industry to understand. I trust that such time frame will be provided. P.S. Thank you, Mr. Chan, for your comments. We agree. Not all stakeholders in this industry are good with writings. In the future, during publicity stage, we will try to rely on flow charts or timetable which are easier for the industry to understand. Comments are well taken. Thank you. Mr. Louis Lung, Chairman. All stakeholders in the industry believe that although this bill is not perfect, at least it is acceptable. This committee had 11 meetings already. I believe this is our last. I trust that it is a milestone that we have put in place. As I heard from many stakeholders in the industry, after this bill is passed, or even before it's passed, the administration should put more effort in publicity, especially to the labor bodies as well as the construction workers. If they are in the middle of payment disputes, they need to voice out as soon as possible. The biggest concerns of the sector that I represent is that they did make payments. However, more often than not, the workers are not paid. When that happens, they will demonstrate or protest at the construction site. The sector wants the labor unions to understand that it is their right to be paid. As soon as they discover that they are not properly paid, they need to voice out immediately. They shall not wait until the procedures is being manipulated by people which cause some social concerns. I hope that both the administration and the Labour Department can strengthen their efforts in publicity. Secretary.
Thank you, Mr. Long. Yes, we want to start publicity as quickly as possible. We have different practitioners taking up different positions in the industry, and we need to make sure that they have a full grasp of the details. Even if you're not involved in the payment dispute, if all stakeholders at different tiers could follow the procedures properly to manage cash flow, then reasonable arrangements will be put in place to make sure that workers get paid after works carried out. We've been in liaison with the labor unions. They are aware of the security of payment bill. And we hope that the problem of wages in arrears can be resolved or significantly improved with passage of the bill. As mentioned in previous meetings, employers are obligated by law to pay the employees. But that's to be dealt with by the law. Of course, if cash flow is better managed by the industry as a whole, there will be more safeguards for workers. Employers are legally obliged to pay the employees. Mr. Gary Zhang. Well, under your leadership, Chairman, we've finally reached this step. We've completed the scrutiny of the bill. It's been very meaningful. I want to reflect one view, and that is this bill should be effective in ensuring payment for work done. But after all, the government is the biggest owner in charge of a lot of public projects. Now, I suppose the government will be able to handle this issue. Let's say if a main contractor files a claim against the government, and if the government, according to the mechanism, is required to assess the performance of main contractors, then this could lead to claims. And this is a real possibility. The Development Bureau should issue guidelines to ensure that there is no abuse of systems and that there will be impartiality between the government and contractors. It's only just for the contractors to receive payment for the work they've done, and the government will of course pay in accordance with the progress of work completed. I know that the industry has been running into some problems recently, and we have implemented measures to ensure payment. And there are also claims, as I understand, under the new mechanism of NEC. Disputes can be resolved as early as possible to expedite payment. Thank you, Chairman Member. Anyone else, Mr. Tony J? Thank you, Chairman. Responding to the point raised by the Permanent Secretary, in fact, this has been a hot issue for the industry. I know that the Development Bureau has implemented guidelines to safeguard payment. Now, I don't know whether this is a recent issue. Does it take a long time for the Treasury to process payment or not? Because, first of all, it seems that the contractors needed to wait for a long time before they receive payment. And about the adjustment of the arrangement, I hope that the administration will consider adopting this approach. For example, if there is a preliminary assessment of the estimate, then payment should be made at least in part, perhaps just pay half the amount, because cash flow is tight for a lot of smaller firms. They may not be able to survive. So something should be done to shorten the payment time frame. I know the government will need to be prudent with the public coffers, but at the same time, let's say the procedure should be streamlined. After receiving a payment request, within 14 days, perhaps the government could pay out half of the committed amount. It should be safe enough, because at the moment, contractors wait a long time before they actually receive payment. So apart from securing the payment of workers, I hope something can be done to help keep the contractors afloat. As I said, we just implemented a mitigation measure taking into account the issues raised by the member. For example, for the payment intervals, we are making them shorter. And we've issued guidelines to government departments so that the department will make payment before the works are carried out in full. I think in general, the payment schedule is in line with the normal practice, but we welcome further discussion with members on individual cases. Now, for variation orders, that means additional works to be carried out. We'll further explore a flexible option for handling the partial payment issue. Any other views? Any questions? If not, I will explain what will take place as our next step. We've held 11 meetings totaling more than 22 hours. I thank members for the hard work in the scrutiny of the bill. Members have been meticulous. I'd also like to thank the Legal Services Division of the Legislative Council and the administration for their efforts. I thank the administration for heeding our suggestions. As we just saw in the proposed amendments, they've made improvements based on our suggestions, so I reckon that members would be happy with them. The legal advisor will be going back to look at the amendments in greater detail. If need be, we can have a further discussion. Now, if there is a need for another meeting to be convened, it will be done. But for the time being, I don't see that it's necessary. Anyway, the Secretariat will will consult me and then inform members whether another meeting will be held. If no further meeting is necessary, a notice will be issued informing members that the Bills Committee has completed the scrutiny of the bill. Now, tentatively, the legislative timetable is as follows. Date of resumption of second reading of the bill is scheduled for the 18th of December. It's a Wednesday. I suppose this is the last meeting before, or last council meeting before Christmas. A report will be made by the Bills Committee for consideration to the House Committee for consideration on the 6th of December, Friday. And then notice for resuming the second reading of the bill is the 9th of December. And the same date for giving notice for moving amendments to the bill. That is the 9th of December. Please note the important dates that I mentioned. If there is no further question, anything from the Secretariat? Right. If not, then there's nothing under AOB today. There being no other business from members, I declare that that's the end of today's meeting. Thank you.